Hey there, everybody. I am going live here to talk today about the public charge rule. And many folks, clients, potential clients are asking us, will this public charge rule keep me from getting a green card? Either from applying to adjust status and having that kick in to keep you from getting your green card through a family member, or overseas if you're doing an immigrant visa. And the public charge rule is still around in one form. The statutory version of it that's been around for decades is still here, despite some really exciting news this week of the Supreme Court and the appellate court that reviewed the issues regarding the public charge final rule. They killed off President Trump's public charge final rule, which made the public charge statutory requirement really, really brutal, difficult, onerous to overcome. And it created this Form 944 Declaration of Self-Sufficiency, which was horrible to deal with. And that lasted about a year. The beginning of 2020, that form was required with green card applications. And my law firm hated it. Everybody hated it. It was really, really difficult to fill out all 20 pages of it. The extra supporting evidence was horrendously hard to put together. And that was all by design. The purpose of it was to identify ways to keep people from getting green cards. And they were fairly effective at creating this huge barrier. But thankfully, it was fought in the courts, and USCIS announced this week that you don't have to fill out that form anymore. If you had filled it out before and your case is pending, and maybe you got a request for evidence for that, you don't even need to respond to the request for evidence where they want more evidence of your finances and background, anything related to that 944. It's actually not required. And so if you're having an interview coming up too, you don't have to worry about being asked about that. The thing is dead. And this is just great news for immigrants who were really bludgeoned with a ridiculous amount of work. That was very unfair, just a big barrier. And I think in many ways it was more effective than Trump's wall at keeping immigrants out. So anyway, what I wanted to emphasize here, though, is there's still a statutory requirement, a legal requirement that you're not a public charge that still exists. So that really onerous final rule is no longer there. Form 944 is not around. But you still have to prove to the US government that you're more likely than not to not be dependent on the government for benefits, that you're not likely to go on welfare and Medicaid and food stamps. Those are key threshold issues when you're applying for a green card with adjustment of status, or at the consulate or embassy abroad. So you got to show that you're not going to be a public charge. That's within the Immigration and Nationality Act. It's a admissibility requirement. So you could be found inadmissible if they think, the consular officer or the immigration services officer, if they think that you are likely to become a public charge and get on government benefits. So the best way under the law, and it's a requirement to show that you're not going to be a public charge, is filling out an affidavit of support. Your sponsor, usually that's your petitioner, has to fill out this affidavit of support and provide evidence that your petitioner has been paying taxes for 3 years or more. It's caught up. You've been paying taxes at least that long when you should, has a job, has assets, possibly. That's always nice to show too, but that the minimum requirements are met so that your needs will be taken care of. You don't have to go on public benefits. Here's a couple interesting things I wanted to highlight. Who's most at risk for still being found to be a public charge, even if you don't have to fill out Form 944? they unfortunately can pick on elderly people, those with a chronic health issue, and lack of job prospects. So these factors still exist. And even with a affidavit of support, which is required, you could still be hit with a public charge inadmissibility issue. Now, there are some immigrants who are not subject to the public charge requirement under the original statute, INA 212. So here's some individuals who are not subject to it. If you're an asylee, if you are applying for VAWA or temporary protected status, TPS, Afghan, Iraqi interpreters. There's others on this list too, special immigrant juveniles, and a few other categories. It gets a little more obscure, but not everybody is subject to the public charge statutory requirement, but you have to be on that list. For the most part, everybody else is subject to it. And the way to get through it is to have a sponsor with really excellent credentials, excellent income, at least over the poverty line. The more, the better. Even if they meet the statutory minimum amount of income that's required, you could still have a consular officer, immigration service officer ask for more. And often that is the form of a request for evidence where they say you need a joint sponsor. Even if your petitioner is making $30K, they might want to see a joint sponsor. So good news this week. The final rule on the public charge is dead, but difficult standards still exist to get through the full immigration process. The public charge inadmissibility requirement still exists. You can get through that, especially if you have a supportive petitioner with good income or other family members or friends who want to help you out with the affidavit of support. I'll stop right there. Hope this turned out and it showed up online. See ya.